This is Bloomberg Law with June Grasso from Bloomberg Radio.
Venezuela's been a very bad actor. They've been, as you know, they've been sending millions of people into our country, many of them Tren de Aragua, some of the worst gangs, some of the worst people anywhere in the world in terms of gangs. And we had some in Washington, D.C. We took care of them very quickly, but they're out of here. They've gone.
The Trump administration used an 18th century wartime act to try to quickly deport alleged members of a violent Venezuelan gang in March, arguing that the Tren de Aragua gang had been sent to the U.S. by Venezuela's president to destabilize the country. But a federal appeals court has weighed in for the first time, blocking the administration from using the Alien Enemies Act of 1798 to deport the Venezuelans, finding that, quote, a country's encouraging its residents and citizens to enter this country illegally is not the modern-day equivalent of sending an armed, organized force to occupy, to disrupt, or to otherwise harm the United States. Border Czar Tom Homan had admitted that the law was being used to bypass normal deportation procedures like hearings in immigration court.
I'm not arguing right here that nobody should get due process. I'm just saying there's a different process under Alien Enemies Act, less of a process you see through Title VIII.
D.C. federal appellate judge Patricia Millett had criticized the government for not giving the Venezuelans any opportunity to challenge their removal.
There were plane loads of people. There were no procedures in place to notify people. Nazis got better treatment under the Alien Enemy Act than has happened here, where the proclamation required the promulgation of regulations, and they had hearing boards before people were removed.
The 2-1 decision from the New Orleans Appellate Court, the most conservative in the country, will most likely end up back at the Supreme Court. Joining me is Leon Fresco, a partner at Holland Knight and the former head of the Office of Immigration Litigation in the Obama administration. Leon, this case has been going on almost 6 months and has been up to the Supreme Court twice already. Catch us up.
This case is a case involving President Trump's proclamation in March of 2025 that the Venezuelan gang Tren de Aragua was a dangerous invading force into the United States, such that its members should be deported under the Alien Enemies Act, which permits deportation without due process. Essentially, the government can just apprehend anyone it says is in the Alien Enemies Act group, which in this case is Tren de Aragua, and deport them. And in the iteration that occurred, people were being deported to El Salvador, to the CICOT prison. Now, there was 2 iterations of this case. The first one started in D.C., where Judge Boasberg had said that the government couldn't do this, and there was the debate about the flights and the debate about whether anything that was done was proper or there should be contempt. But nevertheless, the Supreme Court comes in and says, no, all of that was wrong. None of that should have been filed in D.C. These kinds of cases should be filed as habeas cases. Now, mind you, there was a decision a couple of years ago where Justice Alito had said no more habeas for immigration. But nevertheless, I think that these facts on the ground concerned the Supreme Court so much, they said, well, you got to be able to file something. So fine, we're back to habeas again. So you've got to file them as habeas cases, and the habeas cases have to be in the locations where people were being detained. Well, where were people being detained? They were being detained all over Texas. So there were district court decisions all over Texas, but now finally the main case reaches the Fifth Circuit, and the Fifth Circuit in a 2-1 decision grants the preliminary injunction preventing the removal of the petitioners who were the Venezuelan nationals that the Trump administration wanted to deport under the Alien Enemies Act, saying that at the end of the day, the Alien Enemies Act doesn't justify their removal because there isn't a declared war, and that the actions of this Tren de Aragua gang do not constitute an invasion or a predatory incursion by a foreign nation or a government, which requires, in their view, military-like actions directed by a foreign power. They're saying this is more of some sort of a gang or criminal type of thing, but it isn't actually a military incursion. They don't even get into anything about whether these individuals specifically are members of Tren de Aragua or anything like that. They just say that this manner of invocation of the Alien Enemies Act is unlawful, and so it cannot be used to create deportation without due process. Now, they did say if the Trump administration wants to deport these people, they can deport them under any other grounds that's permissible, just not this Alien Enemies Act provision that doesn't require any due process to occur.
So I was listening to some of Tom Homan, the border czar's comments in the past about this, and he kept saying that they're terrorists. Was the argument that they're terrorists?
Well, first of all, you're correct that there's a very concerted effort, even in this bombing that occurred this week with the Venezuelan drug lords on the boat, that everybody's calling them in the administration terrorists, to try to link that with some sort of military-like action directed by a foreign power to get it as close as possible to the Alien Enemies Act. But what this court is saying is that's not really what these people are. These people are not being instructed by the Venezuelan government to come to the United States and commit war acts against the United States. These are just individual criminals trying to basically profit off of drug and gang activities, but they're not soldiers or quasi-soldiers acting on behalf of the Venezuelan government.
This is a Fifth Circuit decision, a panel of the Fifth Circuit, the most conservative appellate court in the country. As you mentioned, 2-1 decision, a George W. Bush appointee and a Biden appointee in the majority, and in dissent, a Trump appointee. What did the dissent argue?
Well, the dissenting judge, who used to be the Solicitor General of the state of Texas, and a very well-known, strong conservative judge, Judge Oldham, he basically argued that the Alien Enemies Act is something that is so broad in terms of the congressional authority that the courts really don't have a role in reviewing a presidential determination under the Alien Enemies Act. Basically, what he was saying is that the courts should not be given the ability to second guess when the president says there's a war, because this can lead to very dangerous circumstances in that, you know, you have the president who has all of this sort of expertise in the sense that they have the Defense Department and the CIA and the NSA and the Department of Homeland Security to do all of this work and consultation. And if they make a determination that there is a dangerous environment akin to the environment that's required under the Alien Enemies Act, that for the courts, who are just judges sitting there in, you know, Louisiana or Texas or wherever they're sitting, that don't have all of this access to the Department of Defense and the Department of Homeland Security and the NSA and the CIA, et cetera, to be able to come in and say, well, we don't actually think this rises to the kind of war-level threat that is required under the Alien Enemies Act. He's saying that is incredibly dangerous because what is the limiting principle there? Now the judges can decide what is a war, what isn't a war, and that's not what Congress had intended here. The problem with that is, at the end of the day, if you really have no limiting principle on the Alien Enemies Act at all, including whether it can be invoked and who it can be invoked against, then at that point, I mean, there really would be no way for either you or I or any of your listeners to go into court if we were mistakenly apprehended by ICE. ICE could say, you know, Leon or June, you're members of this Tren de Aragua gang and we're sending you to El Salvador. And you could say, yeah, but I've never visited Venezuela and I don't even know any Venezuelans and I'm not a member of a gang. I host the Bloomberg show. And it won't matter because there's no court to bring it to. And so I don't think anyone will be fully comfortable with that kind of decision. And I don't think the Supreme Court was comfortable with that, which is why they didn't issue that decision. And moving forward, I don't think they're going to get there in terms of that ability to just not have any due process determination as to these decisions.
Yeah, a Colorado judge called that argument nonsense.
It's a difficult argument to make. I mean, look, it all depends where you're approaching this from. If you're approaching this from a belief system that everybody in the world acts in good faith, then you could conceivably understand. You'd say, well, why would a president ever want to do something like this if it wasn't absolutely necessary? And why would anyone ever put someone in a detention that isn't absolutely necessary, et cetera? And so under that, you could understand a decision like that. But if you were to approach it from the perspective that sometimes people don't act in good faith or sometimes people make a mistake or anything else, then maybe you do need some due process in that system, because otherwise what is checking those kinds of abuses from occurring?
The ruling could be appealed to the full circuit, the full Fifth Circuit, or could be appealed directly to the Supreme Court. Is there any reason to bother going for an en banc hearing at the Fifth Circuit when the case is just going to end up at the Supreme Court anyway?
Well, it may give you a stronger hand to show how, right now the government doesn't have the strongest hand, and maybe, the government wins in the Fifth Circuit fully, and so then it would be the onus then on the foreign nationals to actually then appeal to the Supreme Court. So from that perspective, they may want to strengthen their hand, but honestly, if the Trump administration is trying to really say, hey, these are the most dangerous people in the world, and we need to get them out as soon as possible, asking for en banc review of the Fifth Circuit doesn't seem to make a lot of sense, because why are you delaying getting to the ultimate outcome here? So I don't think from a political perspective it makes a lot of sense to go for en banc review. It may make sense from strengthening the argument in a typical case, because you might win in the en banc. But at the end of the day, if what you're trying to say is, look, we need a final answer, we need to get these terrorists out of the country as soon as possible, I think you would want the Supreme Court to look at this as soon as possible.
So the Supreme Court never answered the question of whether Trump's use of the Alien Enemies Act is valid. Do you have any inkling from the way they ruled in the two other cases, how they might rule?
Well, I think that at the end of the day, there won't be 5 justices that say that you can't review this general concept of whether it was proper to have an Alien Enemies Act determination. Now, they may give some very strong deference to the administration. In fact, I would be shocked if they didn't give strong deference to the administration. But they may say, look, even with very strong deference, this isn't the kind of case that gets it. I mean, that issue is going to be closed. I don't think there will be any justice that says that an individual person can't come forward and make a claim, well, yeah, but I'm not part of whatever group you're trying to claim I'm a part of. I think those people will 9-0 be able to get due process in habeas or in some other way to be able to make that argument that, look, you may claim there's a problem, but I'm not a member of the problem group. That's the second thing. And then the third thing, which the court doesn't really do too much with, it's sort of a 2-1 way. They say that 7 days is enough to make these claims, so that the government, if they designate you as part of the problem group, you have 7 days to file a lawsuit or you can be deported. And, the dissenting judge there, Judge Ramirez, who was the majority for most of it, but not for this, said, no, you need 21 days at least. And, this is all everybody just making this up out of whole cloth. But the question is, if you don't speak English, you don't have access to a lawyer, what is a reasonable amount of time to give you to file a federal habeas complaint in a court? That's not the easiest thing for someone to do. Imagine, you or I going to China right now and trying to file a court document there where we don't speak Chinese, we don't know anything about the law, we don't know anything. What would be a reasonable amount of time to give a person in that situation? And so that's the question here. And, the Supreme Court's going to have to grapple with that, too.
Coming up next, we'll tell you why 76 Guatemalan children were put on planes during the early morning hours Sunday until a judge stepped in. This is Bloomberg. A group of Guatemalan children are caught in a legal battle. 76 children, one as young as 7, were put on 3 planes in Texas during the early morning hours Sunday to return to the Central American country. But a judge blocked their removal after attorneys argued that the administration was attempting to repatriate them without giving them the opportunity to challenge their removals. Renato Castro is an immigration attorney.
Imagine the position of the children inside those planes today. while we were arguing over the government's practices in court, the children were sitting in a plane at the Harlingen Airport or El Paso Airport for hours, not knowing what's going to happen or why or where they are going or when they're going to be let go. Is just horrendous.
I've been talking to immigration law expert Leon Fresco, a partner at Holland Knight. Leon, why were these 76 children put on planes over Labor Day weekend in the early morning hours?
So here's what happened. So in general, the Office of Refugee Resettlement, which is part of the Department of Health and Human Services, keeps some number of unaccompanied minors who come into the United States in custody until they can be given to some caring adult in the United States that has to be vetted by the Office of Refugee Resettlement. So at the moment, the administration had identified sort of a class of people that was in this kind of detention. And so it was about 600 to 700 Guatemalan foreign nationals that were minors. And what they said was, these minors actually have parents in Guatemala that are still there. And, this is disputed whether that's true or not. But for the purposes of this, let's just start with what the Trump administration is saying. They're saying that all of these 600 to 700 minors basically ran away from home, but they actually have parents in Guatemala. They're not orphans, so to speak. And so what they wanted to do was to say, instead of having them go through the whole immigration deportation process, they basically went to these kids and said, do you want to do that? And it's going to basically end in deportation anyway, and you'll never be allowed to come in. Or do you want to sort of let bygones be bygones and we'll pretend you were never here? And one of these days you could always come back legally. And so their argument is that these kids consented to quote-unquote voluntary departure, which would mean they didn't have to go through any of these proceedings, and Guatemala consented to bring these kids back, so they were just going to fly them back to Guatemala. Well, then the lawsuits come in basically saying, no, this is not what's happening at all. This is a deportation in sheep's clothing, and they didn't give the kids the chance to make asylum claims or claims that they had been trafficked or claims for something known as special immigrant juvenile status, which is that if you've been abandoned, abused, or neglected by your parents, you can actually have a status that allows you to remain in the United States. And so they're saying that those opportunities should have been permitted, and this was essentially a coerced deportation. And so for now, we have an injunction from a district court that prevents this for at least the next 14 days until we can get to the bottom of whether this kind of operation is legal or not.
These kids, some as young as 7, do they just show up at the border by themselves?
Well, it could happen in one of two ways. They could either show up at the border completely unaccompanied, and sometimes that does happen. But more often than not, what happens is they show up at the border with an adult, but that adult isn't their parent. So it's just somebody else who brought them. And then they say, where are your parents? And they say, my parents abandoned, abused, or neglected me. Then they get put in these shelters. And what these kids are essentially trying to do is they're trying to get this status called special immigrant juvenile status, which permits them to stay in the United States permanently if they can show that they've been abandoned, abused, or neglected by their parents, and that a state court, so it would have to be any state, would say that it's in the best interest of this child to remain with whatever now guardian has them in the United States. Now, people think this was a sort of a manipulation of what had been meant to occur. So I'll give you just very briefly. If you want to say a quintessential case, I had a case a long, long time ago where there was a Haitian couple, and what happened was the Haitian couple traveled with their child to the United States, and they were here legally, and what happened was the father shot the mother, murdered the mother. And so the mother is no longer available. The father is now in prison for life. And now the question is, what do you do with this 3-year-old child? Do you send them back on a plane to Haiti? Good luck. And so that's what special immigrant juvenile status was meant for, is no. We're not going to just send a 3-year-old child on a plane and say good luck and just push them out of the plane. We're going to try to find them some guardian like we would if this occurred in the U.S., and then that guardian doesn't have to worry about the child's status because we'll give the child a permanent status. So that's what it was meant for. But over the course of the last 15 years, people figured out, but yeah, I can engineer this claim by just coming to the U.S. by myself as a minor and saying that my parents abandoned, abused, or neglected me, and so that's why I'm coming to the U.S. And so you've seen in some years up to 100,000 of these kinds of minors coming into the United States, and that is what the Trump administration is trying to end. They're trying to end that by basically telling these minors, look, this is going to end in deportation. It's not going to end in lawful status. So voluntarily agree to leave. And so that's what they're trying to do here.
So it is correcting an abuse then of the system?
Well, it's correcting what the Trump administration would argue is an abuse of the system. The people who do this for a living on behalf of the minors would say it's not an abuse of the system. So I'm not going to opine, but I would say that I don't think that the people who drafted these laws in Congress probably would have consented to a situation where any minor could come to the United States and just say they were abandoned, abused, or neglected and get a green card to stay here. I don't think that was their intent. I think their intent was to take care of a situation where there was a case where it was an unforeseen situation and now you have an abandoned minor in the U.S., and what are you going to do with this abandoned minor?
So there's going to be a hearing on September 10th on the children's request to extend the temporary restraining order. This seems like a novel issue. Do you think the case will be one of the ones that ends up being appealed to the appellate court and then the Supreme Court?
I think it will eventually if it gets enjoined by the district court permanently. I do think they will want to go up to the appellate court. I don't think it will work here because the First Circuit's pretty, liberal at the moment, so they're not really siding with the Trump administration. But then would it go all the way up to the Supreme Court, and would the Supreme Court allow these kinds of voluntary? Because really what this is going to come down to is this a deportation? If it's a deportation, they can't do it. They have to follow certain laws in order to deport kids. These laws are established by the Trafficking Victims Protection Reauthorization Act of 2008. So they have to follow all of those procedures. But what the Trump administration is trying to say is these aren't deportations. These kids want to go back home. And so the question is, can they get a court to agree that these kids want to go back home, or is this going to be viewed as a coerced type of situation?
So now the Trump administration is reinstating a practice that hasn't been used since the 90s of conducting neighborhood checks for people who want to become citizens?
Correct. And what's very interesting about this is just like in the Alien Enemies Act situation, where you had a situation where they're reincarnating, let's say, a statute that was from 1789 that has been used, but very rarely. And so all that is old is new again. Here's another example where there is a statute, there's no doubt, and that statute was written in 1802, essentially. And here in that statute, petitioners for naturalization were required to present witnesses who could testify to their qualifications for citizenship. And then in 1981, Congress comes in and says, you know what, let's not do the witnesses anymore. Let's just have an investigation that's better if we need it. And so they were doing investigations from 1981 to 1991. But then in 1991, the government basically stopped because there's a waiver authority in the statute that says, look, if the Attorney General, which now is the Secretary of Homeland Security, doesn't want to do the investigation, they don't have to. They can decide in any specific case not to do it. And so they just decided in every case not to do it post-1991. Well, now they're bringing it back, and they're bringing it back to determine one very specific issue in the statute. And this is what's very interesting, because in the statute it says that the only way you can be naturalized to a U.S. citizen is if you are, quote unquote, attached to the principles of the Constitution of the United States and well disposed to the good order and happiness of the United States. And so now what they're basically saying is, look, we're going to conduct those investigations if we feel it's necessary to find out if a specific person is, quote unquote, attached to the principles of the Constitution of the United States and well disposed to the good order of the United States. But what they're also doing is they're warning everybody, look, if you're applying for citizenship, don't make us come to your neighborhood. Start now and give us this kind of information. Basically, send us some references and some letters that say this on your behalf already from some people so that we don't have to go and do this. And so they're basically trying to add this requirement and sort of give the carrot and the stick. The stick would be if you don't do it, we're going to actually go out to your neighborhood and investigate you. But if you do give us this information up front, then we won't have to do this because you've given it to us up front. So they're essentially reverse engineering this requirement now that people have to give you, positive references in order for you to get citizenship, which hasn't been needed since 1991.
We've discussed other aspects of, seeming to add on to the requirements for citizenship. Is the Trump administration deliberately adding requirements or steps to the naturalization process to slow it down or to ensure that fewer people become citizens?
Yes, I think what they're trying to do is, and what's interesting is, the previous one we talked about had to do with good moral character and not just proving it through an absence of bad moral character, but having to show evidence that you actually had good moral character. I think they realized there that had a very specific statutory definition, and so those kinds of things wouldn't work for that. So now they're attaching it instead to this other issue about whether you have an attachment to the U.S. Constitution and you are disposed to the good order and happiness of the United States, which isn't actually defined. And so then you can make this more nebulous determination. And what I think they want to do is to say, look, if you're a person who's got all of this sort of questionable verbal conduct, I suppose, where you're bashing the U.S. all the time, et cetera, that they don't want to make those kind of people U.S. citizens because at the end of the day, once you make someone a citizen, then you can't deport them if they've been truthful with you the whole time. And they're basically trying to impose an ethos into this system. And you can either say it's good or it's bad. I'm not trying to give a personal opinion here. I'm just trying to say what I think is trying to be done, is they're basically trying to impose an ethos into the system of, we don't want people becoming citizens who aren't 100% thrilled to be Americans and aren't just going to start arguing, oh, America's a rotten place, it's terrible. Well, why did you become a citizen then? And so from their view, they want to sort of cut this off before the naturalization occurs.
Leon, if a client came to you and said, I want to start the naturalization process, would you advise them to wait until after the Trump administration to see what administration next?
No, I wouldn't advise them to wait, but what I would do, and I am doing it as we speak, is I'm saying, look, go get 2 or 3 letters from either coworkers or friends or whoever that say, hey, this person is a good person, they have good moral character, and they have strong allegiance to the United States. And I think you're going to need that, and I think it would be malpractice not to put that in now as part of a new, starting now, citizenship application. I think you need to do that. I do think if there are questions about a person's case, then maybe you don't want to go forward. But if it's just a normal case, I don't think you should have a problem going forward, because in the end you can get judicial review of a denial of a citizenship case. So if you don't have anything to worry about, I think a judge would say, hey, this is ridiculous. Why are you not giving this person citizenship? But if it is a questionable case, so for instance, you take the case of Mahmoud Khalil, who is a green card holder, and he's got all of this sort of background of literature, maybe that's not someone I'd be comfortable taking on as a client at the moment, because I would say this is going to be a honeypot of complications. Maybe it's in your best interest to wait to see if the policies change.
One more thing before I let you go, Leon. The Trump administration is trying in different ways to restrict visas. Tell us what the latest restrictions are for student visas.
Currently, if you enter on a student visa, you can stay in America for as long as it takes for you to finish any studies you're in. So you could enter as a high school student at an Exeter or an Andover or one of those schools, and then go to college, and then go to grad school, and go to PhD, and you never have to leave the country. You could be here 20 years based on that first student visa you were given, and you could transfer a bunch of times. And basically what this new rule would do is say, no. Each time you do something, you're going to have to check in with the government and get permission to do so. The days of changing schools or changing programs or going from one program to another without checking in and getting permission to the government are over. So we're only going to give you permission for the specific program you signed up for, and then you're going to need a new permission for any new program. And so that certainly sounds very rational, but there's a lot of problems in terms of the way the programs work that make this super complicated. For instance, the biggest one being that they only are going to give you 4 years to finish an undergraduate program. And if you notice, the Department of Education basically now says that those programs take on average 6 years to finish. The majority of people are taking 6 years to finish a 4-year program. So the question is, why isn't then what the foreign students are being given in line with what the U.S. students are doing, especially if the foreign students have to pay for those extra years anyway. So it's not like they're getting them for free. They have to pay. It's everyone's benefit. So it's those kinds of things that are going to be debated as this moves forward. But that's basically what's happening under this new rule.
My question is, why is it taking college students 6 years to finish a 4-year program? But that's a question for another day and another guest. Thanks so much for taking us through all these immigration issues, Leon. That's Leon Fresco of Holland Knight. Coming up next, the fight over a Senate tradition. You're listening to Bloomberg. There's been chaos around Alina Habba, President Trump's pick for U.S. Attorney in New Jersey. Federal criminal courts in the state have been basically at a standstill, and a judge ruled last month that Habba has been illegally leading the office since July 1st. She's been vocal about blue slips, which she says stopped her nomination from going forward. And President Trump says he'll sue over the Senate's century-old tradition of allowing home state senators to sign off on U.S. attorney and district court nominees. Joining me is Carl Tobias, a professor at the University of Richmond Law School and an expert on the federal judiciary. Explain the uproar recently about the blue slips. I mean, it comes mainly because of the U.S. attorneys who are not being approved by the senators from their home states.
Yes, that has sparked it, but the problem has been that the administration is not following the tradition of nominating and having confirmed the U.S. attorneys as it did in the first Trump administration when 85 of them went through all quite smoothly on voice votes in committee and on the floor. But Trump has been in a big hurry to seat people, and so he's using interims and actings. And that has led to controversies that we've talked about before, especially in New Jersey, but in other states or districts around the country. And there are 90 plus or so, but only 2 have been confirmed, Pirro for the D.C. district and Quinones for the Southern District of Florida. In that context, the president has urged Senator Grassley, the chair of the Senate Judiciary Committee, to abolish the blue slips for U.S. attorneys as well as for district nominees to the bench. And Senator Grassley has said very explicitly that he has no intention of changing the blue slip policy for either U.S. attorneys or for judicial nominees.
Trump has said that he's going to sue over this. Tell us what the chances of that going through are.
Well, the chances of a judge ruling in his favor are minimal, but hopefully the White House counsel and the Justice Department will suggest to him politely that no court is likely to rule in his favor, so it might be better not to do that. Grassley has been very clear, and the 100-year history going back to 1917 of blue slips has been that the discretion is in the chair of the Judiciary Committee, and different chairs have treated it in different ways. But the point is that it has withstood the test of time, and as senators have pointed out in the GOP, that it actually helps to have that when you don't have the president in the White House of your own party. And so everyone has agreed with Durbin's idea, and that is we won't have separate rules for Democrats and Republicans depending on who occupies the White House or who has the Senate majority. So I think there's pretty strong agreement among senators that it should remain in the chair of Judiciary at that discretion. And as you suggest with your question, in the past there have been a number of Supreme Court rulings that have just said that the executive cannot dictate what the rules of the House of Representatives and the Senate especially are. And so it seems unlikely that the president will make good on his promise to sue. And if he does, it seems very likely that it won't go anywhere. The judges will just kick it out. So I think it's not going to happen. But that doesn't mean something won't happen. In fact, there's discussion on the GOP side about ways to expedite the process. Now, and the easy way with the U.S. attorneys would be to do as they have in the past, but that hasn't proved to be what the White House wants to do and has done so far. So you have all kinds of different variations, but mostly interims and actings as U.S. attorneys around the country. Now, there are a number of people who are, for example, there are 8 of them U.S. attorney nominees scheduled to have a committee vote. So I think the logjam may be broken sometime soon. But Senator Durbin in the committee, in the hearing on 5 nominees, basically said, again, we can't have different rules, and he traced out what had happened in the Biden years and how a number of holds were placed on U.S. attorneys by GOP senators. That delayed Biden's ability, and he only was able to name something like 60 to permanent, 4-year appointments. So we'll see, but I don't think there's going to be a blanket veto coming from Democrats, but they may take it case by case, and so it may take more time.
Years ago, wasn't it Grassley who eliminated the blue slips for appellate court candidates?
Yes, and Trump won in 2017 when there were a number of blue states where vacancies had been left because McConnell and the GOP blocked Obama's choices in the last 2 years, many of whom were highly qualified for the appeals courts. There were something like 18 vacancies in blue states, and the GOP wanted to move them as fast as possible, and so they decided to eliminate the blue slip for appellate judges. And then Durbin, of course, when Democrats came in 2021, retained that, and so Grassley has retained it as well. At some point in the future, they may decide to not do that, but it has to be in a fair way that treats both parties the same way.
So now let's talk about the appellate nomination of Jennifer Mascott to the Delaware seat on the Court of Appeals for the Third Circuit, and why the home state senators are criticizing this.
Well, that was ventilated in committee, especially by Senator Coons, who's a senior senator, longtime member of the Judiciary Committee. And he made a strong point that the nominee, Mascott, has very few, if any, ties to the state of Delaware. She has a vacation home there. She spent most of her adult life in the D.C. area, going to school, Maryland and D.C., and is not a member of the bar and hasn't really practiced there. But more affirmatively, I think the senator explained it clearly that you want to have people who are familiar with the law in the particular state, know the lawyers in the state, know the judges in the state, know the customs of the state and its legal system, especially with Delaware, which, is a corporate center, and so sees a lot of those kinds of cases. But he was also concerned just about her ability to deal with district rulings in areas that she wasn't familiar with, because most of her work has been in administrative law and being a law professor and constitutional specialist, but hasn't done much, if any, litigating in the district courts or, handled things like depositions. And that's a fair amount of what she would see on the Third Circuit. The D.C. Circuit has a docket much more like what she has been working on. And in fairness, she has been in all three branches of the federal government. She worked on the Hill for some time, and she was in Trump 1's administration. In any event, Senator Coons just made a very strong point about the need to have someone who is a consensus nominee, and there was apparently no consultation from the White House about her nomination with the home state senators. And they had already interviewed a number of Delaware lawyers and practitioners and judges. They thought that a number of them would be excellent candidates, but the White House didn't even speak with them or interview anybody. And so he was concerned as the home state senator. That means, I think, he's going to not vote for her.
We saw what happened with the last Third Circuit nominee, which there was so much opposition to Emil Bovee, and he went through. So, I mean, do you think the Republican senators are not going to vote for her because of this?
No, they're going to vote for her. I don't think there's any question about it. I mean, if they voted for Bovee, I think there's no doubt that they'll vote for Mascot, because she doesn't have a lot of the baggage, if you will, that Bovee had, involving the Department of Justice, his representation of Trump in his private capacity, and the many troubling kinds of facts that were elicited during his hearing from the whistleblower and others about his time at the Department of Justice. There are no questions of that sort about Jennifer Mascot, as far as I understand. I don't think there'll be very many no votes on the Republican side, but we'll see. I think all the senators care about their home state prerogatives and want to have on the appeals courts and the district courts people who are from the particular district or state on those courts, because they understand the law, the customs, the practices, and all of that in the home state. And the senators are responsible for that. And so there's concern.
There's concern, but, I mean, nothing changes.
That's right. I mean, because those are their prerogatives, but they can't enforce them when the chair of the committee is of the other party and has made clear that he doesn't intend to require blue slips for circuit nominees. That's the way it is.
Give us an update on, Trump nominations.
Sure. At the appellate level, there have only been 6 vacancies, and they have confirmed 2, Bovee and Hermendorfer for the Sixth Circuit. There are 4 more, one from Maine for the First Circuit, one from California for the Ninth Circuit. They've had a hearing, and I think they're still waiting for a committee vote. That'll come soon. Then Rebecca Tableson for the Seventh Circuit vacancy of the chief judge who's stepping down and taking senior status. So all of the vacancies either have nominees or people confirmed. Other people have to take senior status or retire for Trump to fill any more appellate vacancies. So we'll see how that proceeds. And there have been none, really, this year. There are many who are eligible, but they haven't chosen to. On the district level, there are 19 nominees. There are approximately 35 or 40 vacancies, and most of those don't have nominees yet, but they're moving on those.
Thanks so much for joining me, Carl. That's Professor Carl Tobias of the University of Richmond Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.